Rittenhouse, and the appearances are as before, outside the presence of the jury. And I have sent proposal, or draft number 3 of the to the attorneys this morning, and we'll make a record now on. Oh, would you get what's on my printer, please?
Hey, Judge, this was.
All right. Has everybody received a copy of draft number 3 of the proposed instructions?
Yes. Yes, Your Honor.
And state objections, requests?
Judge, we have no objection. I know the defense has asked that the self-defense instruction be read with every count which is applicable. If they're asking for that out of an abundance of caution, we would agree with that request.
All right, what about that?
Well, Judge, we've had, we've all talked about things off the record in terms of our jury conference. I was under the impression that that was a requirement. I understand we're trying to streamline it. We're trying to not bore the jury with the instructions. I think that is, and if I'm wrong, I'm wrong, but I think that is what the law requires.
I inquired on the message last night. Is anybody familiar with authority on this subject that requires that? That makes. I guess I'll argue with you, and then I'll hear the rest of what you have to say. You know, attention span, as you know, you speak to juries all the time, and when you start repeating yourself, you lose your audience mighty fast. They've got a lot to hear today from me and from you lawyers. And if I am reading the self-defense instructions 5 times, I would expect to lose the audience rather rapidly. And this is so typical of lawyers. We're hidebound. We've always done it this way. And I will tell you that for years I have. I have taken out common elements of things and put them in separate areas of the instructions. And once they learn what the term intent to kill means, I don't have to define it every single time it comes up. And I've never gotten, even to my knowledge, there hasn't even been an appeal on it. My job here is to communicate with the jury so that they understand what the law provides, and I think that can be done better, briefly and concisely, than by repeating the same old stuff over and over again. But given the position of the parties, if that's your position, we'll do it. But to me, it's a monumental waste of time, and it may end up having a negative effect. But, I'm not going to mess around with a case of this magnitude over 2 days or 2 weeks to try. So if you think that risks everything to proceed as I've suggested, then we'll go with the long forms every time. I'm going to have to count on you to make timely objection if you feel that I'm leaving something out on a particular count, because I've prepared it in the 36 pages of instructions. I've prepared them using a brief form without, there's already plenty of repeating going on. But if I have to do longer, you're going to have to object if you think I'm missing something, or it's going to be a waiver, just so you're forewarned. You have to make a contemporaneous objection. Is that clear?
It is, sir. And
All
the
right.
only one that you don't have it in that we had talked about a little bit was count 5. You had, there's a lesser included offense of recklessly endangering safety.
Oh, yeah, I'm sorry. On that one, I do think that, well, no, I didn't put it in there, although it does in the final sentence. It says they have to be satisfied beyond a reasonable doubt of that the defendant was not acting lawfully in self-defense. But I'll try to squeeze the content in there as well. And I guess I'm not sure that I agree with your statement that, well, let's take a look at it. And of course, the state wants me, if I read the self-defense portions in, then they want me to repeat every time retreat and provocation, which you have opposed.
They don't.
So they're going to hear that again. What?
They don't want that anymore.
They don't want it anymore?
Simply because of time.
Okay. I think I'll go back to bed. Okay. But in counts 2 and 3, I gave special instruction only with respect to Mr. McGinnis, because the law is different with respect to him. And we'll get to that.
Okay, very good.
But I didn't reread it with respect to the account involving Mr. Jumpsuit Man.
It would be gross price is the one that I think is where, so you've done attempted first degree with self-defense, attempted second degree with self-defense. But the way that I read it, if I'm reading it wrong, I know the court will correct me, on page 27 of the final instructions, it simply says, here are the elements. I didn't see
You're right.
in there.
You're right. Because as I did, now, let me say, on counts, the attempt murder and the murder, on those, that's the pattern instruction. If I had my way, I think that's overly verbose, and we didn't used to do it that way, and then they came up with this, and I follow it, but I think it could be better stated, but I follow the guidance of the instruction committee because there's more of them than there is me, and they're very bright people. But and then on count 3, I gave a special instruction because of the situation with Mr. McGinnis, but I didn't on count 2 or count 5 because I relied upon the general principles of self-defense on which I instructed them. So if you want me to do it on 5, I need to do it on 2 too. When they've just, that's on 2 also. And that's right after they've just heard it. So, all right.
Concern is that the instruction makes it clear that self-defense is an issue for first-degree attempt and second-degree attempt. I don't know
I
if
understand.
right.
And
So
that's because that's from the pattern instruction. I understand you're thinking, well, because I didn't discuss it in the portion on reckless endangerment, that they're going to think it's not part of it. But the last sentence tells them, and if you are satisfied beyond a reasonable doubt that the defendant's conduct was not privileged under the law of self-defense, you should find the defendant guilty.
can you see that under the recklessly endangering safety one, Your Honor? Is that what I'm just making? Is that what you're telling me?
That's on the, yeah, that's on, excuse me, I'm reading from the fourth count here. Let's see, let's have a look at what I said on 5. See, if I had set this up, I would have put a, well, I'm not going to say what I would have You know, you're right. Well, maybe I misunderstood what you wanted. Did you want the whole self-defense instruction discussed again, or just the clause? And if you are not satisfied beyond a reasonable doubt that the defendant, or that I should say it, is all three elements of the crime of endangering safety of the first degree have been proved, and that the defendant is not privileged under the law of self-defense, you must find the defendant not guilty.
I think that's fine as long as the self.
You don't need the whole.
As long as they're aware that
the whole
self-defense
instruction
is an option.
Yeah, well, you're right. All right, I'm misunderstanding what your email says. So, if you are not satisfied beyond a reasonable doubt, well, there's more missing there than that. You know that? There's not the clause about if you are satisfied. All right, so it'll read at page 27, the fourth line will be, if you are satisfied that all three elements of the crime of reckless endangerment have been proved, and that the conduct of the defendant was not privileged under the law of self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as charged as submitted. If you are not so satisfied, then you must find the defendant not guilty.
Okay.
Is that satisfactory? Okay. What's next?
Else on the instructions?
Defense?
So, Judge, this is more for the record, you've already made, I think, preliminarily, you had talked a little bit about the Ritchie McGinnis instruction.
Right.
Which is on page 8 and 9.
Right.
And the position that I had taken was, one of the lines says, but the defendant does not have a privilege of self-defense as to Richard McGinnis. After that, there's discussion about self-defense and what that means. On page 9, there's a sentence that says, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. I had told you in an email that all the parties were involved in that I thought that there was some incongruence in that in terms of how that reads. I know the court disagrees, but just for the record, I wanted to make sure that that was on there. Because I do think it's confusing. However, I know it's the pattern instruction. I know you took it from the pattern.
Yeah, I'm not even going to argue with you. It is the pattern, and I'm not going to argue with you that it is confusing. But it's an accurate statement of the law. Mr. McGinnis does not have a self-defense status because the defendant has no right of self-defense as to any harm he would cause to Mr. McGinnis. And that's what the instruction is telling the jury. But if he was acting lawfully in self-defense with respect to Mr. Rosenbaum, then it kills one of the elements. I think I'm reading that right. It gives him an absolution with respect to the element of what is the precise element? It's
Element number 2.
part of element, yeah. Unreasonable and substantial risk of death. It says then that the jury can't find that. Well, if they can't find that, they can't find one of the elements, so they have to find the defendant not guilty.
Judge, do you think it's appropriate then on page 9 to say if the defendant was acting lawfully in self-defense as it relates to Joseph Rosenbaum?
At
His
what
conduct
point
in
do you
the-
want that put in?
I just think that makes it clearer. I mean,
Where do you
if-
want to put in?
Where did you say?
Yeah.
On page 9, it would be right, so there's a subheading determining whether the beliefs were reasonable. I think it's the third or fourth to last sentence says, if the defendant was acting lawfully in self-defense, comma,
Okay, with respect to
Joseph Rosenbaum.
Joseph Rosenbaum.
His conduct did not create an unreasonable risk to Richard McGinnis.
Yeah, I'll do that. Any objection?
No.
Okay. Okay, what's next?
Just, Your Honor, that on page, these are small, but on page 34, two of the witnesses, you said one of the witnesses had been convicted of a crime. Mr. Grosskreutz had been convicted of a crime, and Mr. Smith had been convicted of a crime for a juvenile adjudication. So I think if you just say multiple witnesses had been, something like that.
Okay. What number, what page is that on?
I'm sorry, 34. And we are asking for the cautionary.
Do you want the word some instead of one?
Or multiple? Yeah, some is
Several?
fine,
How many was it? 2.
that I recall.
There actually were. Well, I don't think you asked Ms. Sword about hers. There was another witness with convictions, but I don't believe the question was asked. So 2.
What was the answer? All right, I'll put down 2 then.
And then there was some conversations regarding a cautionary instruction regarding Mr. Armstrong.
Yeah, I really struggled with it.
And we had proposed the instruction to the court, which I think we took off of 245 or something like that.
Yeah.
So we are asking, based on his testimony, that the court instruct with that modified 245 instruction as relates to Mr. Armstrong.
Did you want to be heard?
Well, I would stand by what I indicated over the weekend in my email, but I believe that I'm looking up the specific instruction. Say 245?
I think it's
That's testimony of accomplices.
Yeah, and that's a good model for it. That was what I had planned on using if I had drafted it myself.
Judge, I just don't think it's necessary. The evidence was received. The points that the defense wanted to get into were made on cross-examination. Giving any kind of instruction on this would essentially be telling the fact finders how to weigh the evidence. I proposed some different wording. You should not base a verdict of guilty upon it alone unless after consideration of all the evidence you were satisfied beyond a reasonable doubt that the defendant is guilty is completely inappropriate. I can understand where it's appropriate if you're talking about accomplices, but certainly not when we're just talking about a one picture out of 100 and some odd exhibits. So I don't believe it's appropriate. I don't believe it's necessary. I believe that these arguments about pixels and zooming are specious, that their expert used a very similar software program with zooming, was cropping.
There was no objection then, you see that's...
I understand. There's no basis for an objection, and they know that.
I don't know that. Maybe they do, I don't know. I can't read their minds.
This is a forensically sound program used by a forensic analyst who's trained. This image was peer-reviewed. If they want to discuss the proprietary algorithms and how an analyst would not know a proprietary algorithm contained in the software that they are using, that is an industry standard, they can go ahead and argue that. But to give an instruction that tells the jury essentially to ignore this evidence unless everything else proves it is way too far.
Well, this whole business about, well, I don't want to say the whole business, but the Daubert rule is the product of the abuse of so-called scientific evidence by attorneys. There were companies, pension funds, individuals were bankrupted because of legal decisions that were made on the basis of so-called science, which was later shown to be garbage. So when you come in here and you tell me, well, this is what they rely on, I think that's fine, except when my common sense tells me, well, wait a minute, what's happening here when you get an image that is consistent of, I'll say it again, let's say 2,500 pixels, and you blow it up to 25,000 or 250,000, and you don't really know what fills the vacant space, that's a little struggle for me. And this is not being used to decide which camera I'm going to buy or which phone I'm going to buy when I'm at the store. This is being used to decide about whether someone's innocent or guilty of a crime. So that's why when the witness answered, he didn't know. And the only reason I left here and I troubled about it, and in the end, I decided, well, wait a minute, we allow this kind of thing to happen in DWI cases where the officer is asked, well, how does the machine work? I don't know. I just am trained how to operate it. But there is a difference there. That has already passed judicial scrutiny, and this method has been judicially determined to be accurate. Has that been done in this? I don't know. So that was when I was thinking, well, maybe I should give a cautionary instruction. I ultimately, you convinced me in our exchanges that I don't want to be meddling and commenting on the evidence. I will tell you this, assuming that there's a conviction, one or more, assuming that other motions don't contaminate the whatever outcome there is, if it comes out at some time that the method used produces unreliable results, this is going to fall like a house of cards. Because you're basing this extremely important segment of the evidence on something that I'm really queasy about. But as I said when I left here Friday, this is the jury's case, it's not mine. And I'm going to they have your photographs and your video, and they've got the testimony of the person who's worked with it, who knows a lot more about this stuff than I do. So I've decided to leave it alone. So I'm not going to give an instruction on it, but I've made my record on the high risk that I think it presents for the case. Okay, what's next?
The two last things, Judge, are the court had modified a little bit count 6, which was the...
I did.
Okay, so the third element that you have listed there is the dangerous weapon was a rifle that had a barrel length of less than 16 inches or an overall length of less than 26 inches. We have pulled the transcript, talked, and looked at it. Detective Antaramine was asked if this was a short-barreled rifle. He had answered no, he did not believe that it was. That's the only information regarding that.
Was the gun offered as an exhibit?
Yes.
That is evidence.
Correct.
Enough in itself. The jury can measure it.
Okay. Fair enough. I just didn't, the way that I looked at it, there was no other information that a reasonable juror could believe that count 3's been met. So
what are you telling me?
That I'm asking that you take it from them.
They're asking me to dismiss the case for failure to prove.
This count 6. Judge,
Count 6.
there have been many discussions about this count. I'm not going to rehash everything. The state disagrees with the interpretation the court has established. We do not believe this jury instruction is appropriate. We do not believe that the exception or affirmative defense, or whatever you want to call it, was properly raised. We argued about all that on Friday. I'm not going to rehash it. I believe it should go to the jury, and if the jury believes that it was not proven beyond a reasonable doubt, they can return a verdict on that. But the state has objected all along, or has given its version all along. We stand by that version. I believe that this jury instruction essentially swallows the entire statute. We've gone over that before. So I believe that if they raise an exception, then it should go to the jury. We would like the standard instruction. Clearly, the court's not going to do that.
Well, up to now, the motions were motions to dismiss the complaint. And you filed a very nice brief, which well explained what the law is. And of course, we were dealing with what the complaint stated and whether the complaint stated sufficient facts to bring the case to court. And the court is confined on that kind of a motion to what's in the complaint and whether it meets the law. And as you pointed out, these offensive matters are affirmative defenses, and the DA doesn't have to plead them. So that's why I ultimately denied the motion to dismiss, although I think it ought to have been mighty clear that I had big problems with this statute. I've made no bones about that from the beginning. And there always was access to the Court of Appeals all along here. Well, I guess that's not fair for me to say because I was sitting on it. But so shame on me. But I ultimately read the statute and have, even when I ruled on the motion to dismiss, I was of the opinion that the statute was as interpreted by the defense, but there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Yes.
We can either measure it, or you can stipulate that it does not meet what I've stated are the requirements. And if it is out of compliance, if the barrel length is less than 60 inches, or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel length is appropriate.
Isn't legal?
It is not a short-barreled shotgun or a short-barreled rifle. Yes.
Either by barrel or by overall length?
Correct.
All right, and then count 6 is dismissed. What's next?
One other thing, Judge. I had filed on November 8th, we had addressed a motion for mistrial with prejudice. The court had taken that under advisement. What I had informed the court was, so I have filed something in writing on that. I know the court likely hasn't had an opportunity to review it. I don't know. I'm assuming,
I haven't even seen it.
Okay. I'm assuming that we're going to go obviously through closing arguments today, but I did want to make sure the court was aware that it had been filed, and at some point have the court make a final ruling on it, just for the record.
I will,
Okay.
if it's necessary. Okay. Came in this morning? Okay. Okay, anything else?
Judge, were you ever able to get the defendant's interview link that we sent to play? The Washington Post story?
I did receive that. I did receive that.
It relates to the motion. That's the only reason I asked. The defense motion, it relates to that.
Well, I'm not going to take up the motion now.
I understand now. I just know there were technical problems. I just wanted to make sure they were ironed out.
I did receive it.
Okay.
Okay. Anything else right now?
Judge, are you done? Attorney Charles. The only thing, Judge, in our arguments, we would like to indicate that pointing a loaded machine at someone without reasonable justification would be a criminal act without citing, the specific statute, but that pointing under 941.20 is a crime. We would like to point that out, and we just wanted to preview that. So if there's objection, we can handle it now.
Okay. Do you want to respond?
We would object. This is once again relying on the exhibit that is so far out of focus, and there's been nothing in the record. When I specifically asked the Detective Howard regarding the strong arm robbery, I asked about it. Strong arm robbery while masked. I asked about it. It's in the record.
The struggle I'm having with that is, and I will, well, I'll leave that. How do we know it was pointed at or toward Mr. Zeminski or Mrs. Zeminski or whomever? You have a theory that it was pointed in that direction. I agree with that, but the statute's prohibition is pretty explicit, and I'm not sure that the evidence that you have, especially because it's just well, not just especially, but in part because it's just a regular photograph. It's not multidimensional. It doesn't show the exact area at which the firearm was aimed.
Judge,
Even if you see the firearm.
again, the photograph is perhaps the fifth or sixth most relevant piece of evidence on this topic.
Most what?
Fifth or sixth most relevant piece of evidence on this topic. We have testimony, we have videos. I'm not going all over that again. The defense submitted their own exhibit of the FBI video with the Zeminskis denoted as being the only two that were on that side of the Duramax. Mr. Zeminski starts out by one of the windows of the Duramax. I guess it would be the rear passenger side window, and so there's no real dispute that they are in that area, and that is where we argue that he is pointing the weapon. It's for the jury to decide if he's pointing at Zeminski's or not.
So it's for the jury to decide. It is not for the jury to speculate. I mean, let's look at the statute. That's a good place to start. Was it 941.20?
20.
Yeah. And that brings up, a separate issue, I suppose, that what is the role of Mr. Rosenbaum, assuming the defendant violated that statute? That's the very theory that the state has proceeded on in the first place, is that the defendant was a vigilante who was getting himself involved in something that was not his concern. And now you're telling me that would justify Mr. Rosenbaum's actions? I'm kind of struggling with that, too. How would that justify? I mean, what does the jury do with that?
I don't fully understand the court's question. I would also note that he
Is
did point
you?
the weapon at Mr. Rosenbaum.
Pardon me?
He also pointed the weapon at Mr. Rosenbaum before the shooting. While he's being pursued, he turns and points it at Mr. Rosenbaum.
Well, there's no question about that.
Correct.
That he's being chased by him.
Pardon me?
I said he's being chased by him.
Well, they've made it much more complicated. It used to be points or aims of firearm at another. I'm not seeing that exact language anymore, but I'm not seeing it here in the statute that there would be a broad enough sweep to capture some wrongfulness in just pointing the firearm towards the west without evidence that it was pointed specifically at or toward another? What am I missing?
1A is endangers another safety by the negligent operation or handling of a dangerous weapon.
Did you start that over? I'm sorry.
Sure. 1A is endangers another's safety by the negligent operation or handling of a dangerous weapon. We would argue that it is. If the court feels otherwise, we just simply will talk about it and not call it a crime.
Where was the firearm aimed? You say at the Zabinskis. I didn't hear the Zabinskis come in here and say that. Who said it?
Except for looking at the video, and that's who is over there. That would be the only
I beg
evidence.
your pardon?
Looking at videos and indicating that those are the ones who are over there, that would be the only evidence.
I can't say it. I'm not saying it didn't happen. I'm saying I don't think I can give an instruction to the jury telling them, something when I don't see the statutory.
We're asking for instruction. We just, in our closing, in our arguments, we just wanted to say that it's.
I think it would be okay for you to state what the law says, but you have to be careful because the jury cannot be invited to speculate. So I don't want to. There's such a universe of possible statements that could be made that I don't want to try to, rule in advance. I've refrained from doing that. I always try to, because I can't read your mind. But so I'm not going to say they can't mention that at all. That it's unlawful to point a gun at somebody. The jurors probably have a sense of that anyway. But as to what might be said, I can't tell you what's in and out of bounds. Okay, what's next?
All we have.
Okay, ready for the jury? I'll probably take a break after the lengthy instructions, and have to call from the outside to, let's see.